Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome to Ask a Lawyer here on CP24. Good to have you back for another week. My name's John Scholes, and be joined momentarily by Lior Samfiru, of course, employment lawyer from EmploymentLawyer.ca. You're always encouraged to reach out to Lior on your own time. You want that conversation to be lengthy, more private, something you want to talk about, no problem. 1-855-821-5900, or you can use email ask@employmentlawyer.ca and the website pocketemploymentlawyer.ca, which will take out for a spin a little later on in the half hour. Common questions when it comes to Ontario employment law, Ontario specifically, because that's where we are here in the GTA. So stick around for that. For the main topics, the phone calls, emails, we got a full half hour to get through. So let's get at it as we get through it. Lior, welcome to the show, pal. It's always a week that was. Case of the day on your end. What's going on?
I spend a lot of time when I'm not here on TV, when I'm not in front of the camera, talking about employment law with individuals that are facing workplace issues. Most of the time when people call me, they're not happy. They're stressed out. Something has gone wrong at work, but I hope that once they're done speaking to me, they feel better. They feel more empowered. They know their rights. That's what we also do on this show. We want to tell you what your rights are in the workplace. You have rights. You have entitlements. Your employer can't just do whatever it wants. Too many people, though, don't understand that. They don't appreciate what the law does and can do for them. It's okay to ask, what can the law do for me? And on this show, we answer that. We tell you what to do if you're let go, if your boss is threatening to let you go, if you're put on a performance improvement plan, if your job has changed, or maybe you're being mistreated in the workplace. We tell you what that all means, or what you can do, and how the law can solve that problem. You have extensive entitlements, and you'll learn about them on this show every single week. And beyond just the 30 minutes of the show, we squeeze in as much as we can in 30 minutes. But beyond that, you can always reach out to me in the office to have a private discussion, phone or email. Throughout the show, you'll see that contact information, so use it. But I always like to start off with the situation that came across my desk. I spoke with a gentleman earlier this week who unfortunately felt that he had to leave his job after getting into a dispute repeatedly with his employer. Well, what was that dispute about? This gentleman had worked many hours worth of overtime, and his employer wouldn't pay for it, and they argued about it. The employee tried to get the employer to pay for it. That never happened. And what the employer kept saying is, well, we didn't ask you to work the overtime. You didn't do it because we demanded it, so we're not going to pay for it. Of course, this employee was saying, no, I worked the overtime because I needed to get the job done. I'm a good employee. I'm a hardworking employee, but I need to get paid for it. So after a while and being owed a lot of money, he quit in frustration, and he called me. And his question to me was this: I'm owed about $5,000 or $6,000 in overtime. It's a lot of money. How do I get it, and can I get it? So first of all, yes, he can get this overtime, because if he works overtime in Ontario, if it's over 44 hours a week, you have to get paid time and a half, even if the company has not asked you to do it. In fact, even if the company has told you not to, but you worked overtime because you had to get the job done, your employer must pay for it. But it gets actually more interesting than that. The failure to pay this person what he was owed, the failure to pay him overtime, means that him resigning may actually be a constructive dismissal. If you leave your employment because your employer is not doing what it's supposed to do, it's not living up to its end of the bargain by paying you what you're owed, the law may consider that to be a termination, and now you are owed severance. So this person, not only is he owed that $5,000 or $6,000 in overtime, he may be owed about $50,000 in severance. For him, severance would be about 8 or 9 months' pay, a significant amount of money. So a reminder there: employers have to pay you what they owe you, whether it's vacation pay, overtime pay, minimum wage, etc. If they don't, that could be a constructive dismissal. But of course, I want you to do the right thing. If that sounds like your scenario, before you quit, I want you to call me.
Is it always wise, Lior, in this case, $5,000, $6,000 a lot of money? Is it wise, I guess, for obviously the employee, but even the employer, to keep track of someone's overtime, just so there's no disputes going forward, right?
So it's actually, to use the word wise, it's actually wiser for the employer to keep track of hours, and here's why. If an employee says, I worked 50 hours of overtime, unless the employer has proof otherwise, that employer has to pay for those 50 hours. So an employer should have a way to show hours, whether it's a punch clock or some other mechanism to show how many hours the employee worked. So for an employee, yes, it's always a good idea to keep track. But remember, ultimately, the company has the obligation to keep track of hours, and if they don't, they may be liable to pay.
I want to remind you that every week you have the opportunity to join Lior and I on the radio show, News Talk 1010, our sister station. 1 p.m. on Sundays is when that happens. It's a complete hour and all kinds of opportunity for the entire 60 minutes to call into the show and ask your questions. Your question may appear on this show, right? We talk about it in just a bit. In fact, our first phone call for the night here is coming up right now. Listen up.
I'm a 60-year-old employee with over 30 years of service. I work for a large municipal employer. I'm in a non-union position. And 6 months ago, I was given a letter telling me that my position was going to be terminated. During that time, they said there's going to be new positions being created, could apply for those jobs. Am I entitled to a severance even if I have not applied for any of the new positions? And number two, I continue to ask my employer for information on my termination. They have not provided any information whatsoever. It's a couple of days away.
Well, what do you think?
So yes, if he's losing his job, he's going to be owed severance, absolutely, in this situation. And if the company says, well, you could apply for another job, he may want to do that. He may want to continue working and apply for another job, but he doesn't have to. And the failure, if you will, to apply for another job doesn't deprive him of his severance. If the company wants him to have another job, they can offer him another job. And then it's his decision whether to take it or not. But no, in this case, ultimately, he's going to be owed severance. Now, I want to point out one thing. This person has received 6 months advance notice of his termination. 6 months, you're out of a job. So that 6 months does count towards his severance. But the real question now becomes, how much severance is he owed? That's what he wants to know. He's waiting for the company to tell him. Well, he doesn't have to wait for the company. I can tell him how much he's owed. But to show you how much he's owed and how you can find out for yourself, we're going to go to the severance calculator tool. You can find that at EmploymentLawyer.ca. Let's put that in there and let's see how much severance he's actually owed. So he's a 30-year employee, 60 years of age, is in a professional role. He was offered 6 months notice. That amount counts towards his severance, except you see he's owed 24 months. So not 6 months, 24 months. So that's the number. That's what he's looking for. By the way, so we talked about the severance calculator. It's free and anonymous. Check it out for yourself. You don't have to put in any contact information, and you'll be surprised by just how much you're owed.
All right, main topic for the evening, as I said, common employment law questions in Ontario. That's on the way, but we'll take a short break first as we get deeper into Ask a Lawyer here on CP24. Stick around. We're coming right back.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. Reach out anytime you would like. There's several different ways to do so. To reach Lior, the phone number is first, 1-855-821-5900. Email, that's good, ask@employmentlawyer.ca. You can always scan that QR code in a moment here as well. Okay, main topic for the night. As I mentioned, common employment law questions in Ontario. I'm going to throw these at you, Lior, so get ready. Number one, can my employer cut my pay or demote me as a form of discipline? What do you think?
No. The answer to that is absolutely not. Now, there's some things your employer can do to discipline you. They can provide a warning. In some situations, they can provide a paid suspension. But generally speaking, no, they cannot reduce your pay. They cannot demote you. They cannot change the terms of your employment in a significant way. And that's assuming they even have a right or the ability to discipline you at all. There's a justification for it. Anytime your employer makes significant changes to the terms of your employment, this concept of constructive dismissal should come up. You may be able to treat your employment as being terminated if those terms of employment are changed in a significant way. Now, that's true even if your performance may be lacking. That's true even if you've done something wrong. I'm not saying you've always done everything right, but that still does not allow the company to just take the job that you had and make it something completely different. If they try to do that, you call me right away.
Question number 2, Lior, can I lose my job if my insurance provider cuts off my long-term disability benefits?
So being on disability and getting disability benefits is different than what happens in your workplace. Your disability insurer, for whatever reason, may cut you off those benefits. That may be illegal, by the way. We have a whole team at the office dealing just with that, getting people back on disability benefits. But even if they have the right, for whatever reason, to cut you off benefits, it does not mean that your employer can do anything to you. In order to be off work legally without the company doing anything, all you need is a doctor's note, okay? Your insurer can't force you to go back to work. Your doctor makes that decision. So if you have a doctor's note saying that you cannot work and you need to be off, your employer cannot and should not do anything to you. You cannot be let go because you're injured. You cannot be let go because you're sick. You cannot be let go contrary to what your doctor is saying. If any of that sounds familiar, please call right away.
We are discussing common employment law questions in Ontario on the show this time around. Number 3 is, can my employer fire me for cause if they have a good reason to?
Well, reason is different than cause. Your employer may have a reason to let you go. That does not mean they have cause. Cause means you've done something so bad that the company can let you go and pay you nothing. It is very difficult to terminate for cause. It's reserved for the worst offenders. So if you stole, yeah, you can be let go for cause. If you committed fraud or you hit somebody, yeah, you may well be able to be terminated for cause. But let's say your performance is not up to par. The company, if they want to let you go, they can, but they would have to pay you full severance. That would be a without cause termination. I want everyone to remember, a termination for cause, very rare, very difficult to prove.
All right, Lior, one final question on the topic tonight. Can my new employer let me go shortly after luring me away from another company?
So you worked for a company, you were recruited by a new company, you decided to go there, and eventually they let you go. Can they do that? Yes. Remember the general rule, your employer can let you go for most reasons as long as they pay proper severance. But that's the key. If you've been recruited from another company only to then be let go, that new company may have inherited your service with the previous company, and they have to account for that service when it comes to calculating your severance package. So you may have only worked for the new company for 6 months, but maybe you had 20 years with the previous company. So you now may be a 20-plus year employee and get severance accordingly. So if you've been recruited from another job only to then be let go, you may be owed enhanced severance.
I want to remind you, as we went through in the first segment of the show, you can catch Lior and I on the radio show Weekly News Talk, 10:10, Sundays, 1 p.m. That's where we get all these fantastic phone calls from and talk about them. Phone call number 2 is coming right now.
Is there a time deadline for applying for severance from a company? I was let go from my company and I got a ROE, and it said that, there was a layoff due to lack of work. But in the meantime, what happened was I got cancer, and they said that they didn't have to give me anything. I was basically given about maybe 3 weeks notice.
All wrong.
John, frustrated to hear that, because forget about being a lawyer. Isn't it wrong on a human level to treat someone that way, an employee, when they have cancer? My God, that's a terrible thing to do. So let's answer the first question first, which is, how long do I have? Generally speaking, if you lost your job, you have 2 years from that time to pursue your termination entitlements. That's a strict deadline. It's not 2 years plus a day. It's 2 years. So don't wait. Let's make sure we deal with your situation right now. Beyond this, okay, obviously this person is owed severance. They lost your job. But if part of the decision that had to do with losing their job is because they had cancer, because he was sick and unable to work, that could be a human rights violation. You can't be let go, or the company can't refuse to bring you back because of that disability, because of that medical condition. Again, human rights violation. So yes, severance is owed. Of course severance is owed. Potentially other damages as well. What this company did, John, completely wrong.
Always great to have the phone calls on this show, Lior. As you know, we got phone call number 3 coming up, but that's going to be doing after the break, and so much more. So stick around. We'll continue with lots more of Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. Reach out to Lior Samfiru, EmploymentLawyer.ca anytime. Phone number 1-855-821-5900. You prefer the email address, you can use that as well. Ask at EmploymentLawyer.ca. Okay, phone call number 3. Again, News Talk 1010, Sundays 1 p.m. You'll catch Lior and I for a complete hour on the radio, answering your questions, educating you like we do during this half hour. And we'll get to phone call number 3 from the radio show right now. Listen up.
I have a friend who works for a large chain for 9 years. Now, they've put all the managers on layoff, but they didn't really give a time like when they're going to hire them back. They said, oh, we'll promise that we'll get you guys back once the layoffs are over. He knows that he can take a dismissal and he can get severance. But what is the time frame where if he stays on the layoff that he's not going to get severance anymore? Is there like a time frame where he's given up the eligibility of getting a severance if he waits too long?
It's a great question.
It's a great question. So the answer is, generally speaking, he can wait as long as he doesn't go back to work. If he gets called back to work and decides to go back to work, at that point he's considered to have accepted that temporary layoff and he cannot pursue his severance. As long as he's on a temporary layoff, he can wait. Now, one of the reasons you don't want to accept the temporary layoff is because if you accept it, you've given the company the right to do it again. And think how problematic that is. You can be in a situation where you're called back to work, you work for a few months, you're off for a few months, back and forth, and that's not a way to work. And that can happen if you accept that initial temporary layoff. So he can consider himself as being terminated. And same with you at home. If you're put on a temporary layoff, you may be able to consider that a termination of employment. You don't have to wait. You don't have to accept it. Of course, the final question in this equation is how much severance is he owed now as a result of this termination? For that, I'm going to go once more to the severance calculator. You'll find that at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. And let's see what that gives us. So we know this person has been there for 9 years, 48 years of age. He's waiting. He hasn't been offered anything. Well, he can treat it as a termination, and we see that he's owed 12 to 14 months of severance. 12 to 14 months. That's what's at stake for him. And by the way, as easy as I just read it off the screen right now, you can as well check your entitlements just as easily. Just go to pocketemploymentlawyer.ca.
I want to grab a quick email here before we take a break, Lior, for this week. It goes like this. After years without one, everyone has just been handed new employment contracts and asked to sign by Friday. Should I?
Well, not only should you not sign, you should run as fast as you can in the other direction. That's bad news. Your employer, if they're coming to you now and say, we need you to sign a new employment agreement, it's not to keep things status quo. If your employer wanted to keep things status quo, they wouldn't have new employment agreements being asked to sign. So oftentimes an employment agreement, when it's being introduced, it's there to protect the employer. It may have terms that limit your future severance, can cost you tens of thousands of dollars. It can have terms there that give the company the right to change your job, your pay, your hours, to allow the company to put you on a temporary layoff. And the list goes on. So no, it's bad news. Don't sign that document, certainly not without me seeing it first. Send that over. Let me tell you what it does and what it says. You cannot be disciplined or fired for cause for refusing. And in most cases, that's exactly what you should be doing.
Okay, we'll take one more short break, guys. Get into a question from Lior's live stream efforts on the other side of this, right here on Ask a Lawyer on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, we're back. I got a few minutes to go here. In the meantime, you'll want to reach Lior after the show. You always have the option. The phone number, 1-855-821-5900. There you go. Email is ask@employmentlawyer.ca. And you can also catch Lior weekly and other lawyers in his firm on the weekly live stream. That's on Facebook, YouTube, and LinkedIn. You want to take part, see what it's all about, at stlawyers.ca. That's how it goes. Here's a question for this week. I love this, Lior. In an email, my boss said they can no longer justify my position. However, since they felt I was likely going to retire later this year when I turned 67, we could mutually part ways. How does that work?
Yeah, John, it would work really well for the company. They could save a bunch of money that way. Well, no, it doesn't work that way. This is completely illegal. There's no such thing as expectation of retirement. By the way, we got rid of mandatory retirement, frankly, across the country many years ago, probably 15 to 20 years ago now. And because of that, you can work as long as you want. 65, 75, any other age. Doesn't matter. It's up to you. And only you, the employee, can decide if you're going to retire, if you're going to resign. Now, if the company wants you gone before you're ready to leave, that's a termination. They have to pay severance. That's a full amount of severance. That could be as much as 2 years' pay. But it's even more interesting than that. If their decision to part ways with you has anything to do with your age, well, that's age discrimination. You cannot be let go because of your age. Even if that's one of several reasons you were let go, it's also already illegal. Can't do that. So, number one, you can work as long as you want to. Number two, you cannot be let go because of your age, even if that's part of the consideration. And finally, of course, if you're let go, you're owed severance, and your age is going to impact that and make it more severance.
Can an employer kind of ask, what are your plans for the future? Is that a no-no?
They can ask the questions just so they can plan accordingly,
Right.
But they can't push the issue. They can't suggest that you should retire. They can't ask you that weekly. Ask once, get the answer, and move on. That's the only thing.
That's exactly what we're going to do. We are fresh out of time. Thank you so much for your contributions to the show, and you'll catch us next week as well. In the meantime, contact Lior and his team. The phone number, 1-855-821-5900. Email ask@employmentlawyer.ca. And that website, remember, it's free, anonymous. It will make it smarter and give you access to the severance calculator, pocketemploymentlawyer.ca. Thank you so much. And weekly radio show, of course, Sundays, 1 p.m. on News Talk 1010. We'll catch you next time right here. Ask a Lawyer on CP24.